Can creditors take inherited property? Creditors can reach inherited property when they have a lien on the property, a valid claim against the estate, or a claim against an heir after the property has been distributed. The key question is whose debt it is: the deceased owner's debt, the estate's debt, a trust-related debt, or the heir's personal debt. Estate creditors matter first while the property is still in probate or estate administration. Valid debts of the deceased person are handled before heirs receive clean ownership. I'm Rhett Fruitman, co-founder of Inherited Property Match. My background includes Citi Private Bank, CBRE, and helping families navigate inherited property sales across the country. This is general information, not tax, legal, financial, or real estate advice. Before you sell inherited property, speak with a CPA and, when probate or trust administration is involved, an estate or probate attorney. Can secured creditors take inherited property? Yes. A secured creditor can enforce a mortgage, HELOC, property tax lien, judgment lien, IRS lien, state tax lien, or HOA lien that is attached to the property. A mortgage does not disappear when the owner dies. In many family inheritance situations, the lender may not be able to demand payoff only because title transferred after death, but the loan still has to be kept current or resolved through sale, refinance, payoff, assumption, or another lender-approved option. For a sale to close with clear title, recorded liens usually need to be paid, released, discharged, or otherwise resolved. Can unsecured creditors force the sale of inherited property? Yes, indirectly. Credit card companies, medical providers, and personal loan lenders usually do not have a lien on the house itself, but they can file claims against the estate during probate. If a claim is valid, timely, and the estate does not have enough cash, the executor or personal representative may need to sell estate property to pay it. Can a credit card company take an inherited house? Not directly in most cases. It must use the estate claim process, and it gets paid only if the claim is valid and state law gives it a right to payment. Do heirs inherit debt? Heirs usually do not become personally responsible for the deceased person's debts. The estate pays valid debts from estate assets, and if the estate runs out of money, remaining unsecured debts often go unpaid. An heir can become personally exposed if they co-signed, guaranteed the debt, were a joint account holder, received property before valid claims were resolved, or another state law exception applies. This is why heirs should not rush to transfer title or distribute sale proceeds before the creditor period is handled. Can an heir's own creditors take inherited property? Yes, after distribution. Once inherited property is titled in the heir's name, it can be treated like any other asset the heir owns. Before distribution, a personal creditor usually cannot place a lien directly on estate-owned real estate, but state law may let that creditor pursue the heir's right to receive a distribution. If an heir has a judgment, bankruptcy, tax debt, divorce claim, child support issue, or collection action, talk to an attorney before changing title. Can a spendthrift trust protect inherited property? Yes, a spendthrift trust can protect inherited property while the assets remain inside the trust, but the protection narrows once the trustee distributes the asset. Spendthrift protection is state-specific. Common exceptions can include child support, spousal support, certain government claims, creditors who help protect the beneficiary's trust interest, and claims that state or federal law allows. A trust also does not erase a mortgage, property tax lien, recorded judgment lien, or valid creditor claim against the deceased person's estate. Can Medicaid estate recovery affect inherited property? Yes. Medicaid estate recovery is a state-run claim process that may seek repayment from a deceased person's estate for certain benefits paid. Federal rules include important protections. States may not recover from the estate while there is a surviving spouse, a child under age 21, or a blind or disabled child of any age. States must also have hardship waiver procedures. Because Medicaid estate recovery is highly state-specific, heirs should verify the rule in the state where the property is located before assuming the home is safe to sell or distribute. What assets are harder for unsecured creditors to reach? Life insurance with a named beneficiary and many retirement accounts often pass outside probate, so ordinary estate creditors may have less access to them than probate assets. But beneficiary designations, tax liens, Medicaid estate recovery, trust rules, and the beneficiary's own creditors can change the result. Homestead protections can also limit forced sale in some states, especially for a primary residence. But homestead rules do not wipe out every lien. Mortgages, property taxes, HOA liens, and certain tax claims often still need to be resolved. What should heirs do before selling inherited property with creditor issues? First, separate secured debts from unsecured claims. Second, confirm who has authority to act: executor, personal representative, administrator, or trustee. Third, ask the estate attorney which claims are valid, which can be disputed, and which liens must be cleared before closing. Fourth, avoid premature distributions until creditor deadlines, title issues, and payoff requirements are handled. If you inherited property and need help finding a broker who understands estate-related sales, Inherited Property Match can connect you with a vetted broker experienced with inherited property. The match is free,